Structure proceeding. This court consists of two finalist teams. The final round shall be conducted as a single match. Each team shall argue once on the side already allotted. Issues. The moot court proposition consists of three issues. Team shall divide the issues between speaker 1 and speaker 2 and 3. Camera and microphone protocols. All the members of both teams must keep their camera switched on throughout the final round. Only the speaker addressing the bench shall unmute. Non-speaking members must keep their microphones muted. Decorum and connectivity. Teams must ensure stable internet connectivity and a professional environment. Proper courtroom decorum must be maintained at all times. Any misconduct or violation of rules may invite penalty or disqualification of the discretion of the organizing committee. Thank you.
Coming to the time reservation and issue allocation. Each team is allotted a maximum time of 45 minutes for their oral submissions. Before the commencement of the arguments, the court masters shall record the time reservation and issue allocation team-wise. First, that is the petitioners LVMC 012, kindly reserve and declare your time and issues allocation. One of the speaker is requested to unmute and tell the time reserved and the issues that are going to be taken.
Respected court master, am I clearly audible?
Yes.
Yes. The speaker 1 will be addressing issues 1 and 2 and will be speaking for a total of 23 minutes. Speaker 2 will be addressing the third issue and will be speaking for a total of 22 minutes. Thank you.
Organizers, I would like to brief you about petitioner list team number 012.
Yes, ma'am.
And the respondent?
019.
And all the judges are here?
They are joining in a while, ma'am, in a minute. So we can start. They have said they are just joining.
Kindly write it down the details of team on the chat also, so we can easily write it down.
Sure, ma'am.
Yes, ma'am. We will do it as soon as we are done marking, ma'am. Moving to the respondents.
If rest of the judges are comfortable, then we can start.
Yes, ma'am.
Yes, ma'am. Moving to the respondents, that is LVMC 019. Kindly unmute and declare your time and issue allocations.
Yeah, so I'll be speaker 1 and I'll be taking 23 minutes and I'll be dealing with issue 1 and issue 3. And my researcher for this round will be the speaker. He will be dealing with issue 2 for 19 minutes and will reserve 3 minutes for rebuttal.
Thank you. Now to move on with rebuttals and surrebuttals, it shall be only at the permission of the honorable bench, a maximum time of 4 minutes for rebuttal and 3 minutes for surrebuttal will be allocated, only at the discretion of the honorable bench itself. Granting or refusing the same time shall remain at the discretion of the honorable bench at all times. We shall now proceed with the final round. That is, to clarify, petitioner team code is LVCM 012 and the respondent team code is LVCM 019. The petitioner speaker may kindly unmute and begin upon the permission of the bench.
Am I audible and visible to the court master and the judges?
Yes, you are.
The counsel seeks permission to approach the bench. Much obliged. The counsel recognizes the gracious presence of your ladyship. However, for the convenience of the proceedings, the counsel seeks permission to address the bench collectively as your lordship.
Even sir is comfortable to.
Yes, you may.
Much obliged, Your Lordship. Your Lordship, the council is appearing before the Honorable Court in the matter of Tech Justice Collective versus Union of Bharatavarsha on behalf of the petitioners under Article 32 of the Constitution of Bharatavarsha, as there are grave violations of the fundamental rights, mainly Articles 14, 19, and 21. Your Lordship, the council seeks permission to briefly state the facts of the case.
Yes, please.
Much obliged, Your Lordship. Your Lordship, in the year 2023, the Republic of Bharatavarsha has launched a national AI mission to integrate AI into public administration, policing, and welfare for efficiency and predictive governance. Your Lordship, in the December 2024, the Himachal Pradesh has introduced SurakshaNet, an AI-based predictive policing system using facial recognition, social media analytics, and behavioral data developed with the private and the foreign entities, Your Lordship. Your Lordship, Tech Justice Collective has reported that SurakshaNet is disproportionately targets marginalized groups, accesses Aadhaar-linked data without consent, and lacks transparency audits or appeal mechanism. Your Lordship, after student Raghav Menon has detained as a potential disruptor, Tech Justice Collective has filed a PIL under Article 32 alleging violations of Article 14, 19, and 21 and an unconstitutional delegation of the state power to the Private AI Act, as Your Lordship. The council, if the bench is satisfied with the facts of the case, the council seeks permission to proceed with the issues.
You may counsel.
Much obliged, Your Lordship. Your Lordship, the issues in the said case are whether the public interest litigation filed by the Tech Justice Collective is maintainable under Article 32 of the Constitution of Bharatavarsha, and secondly, whether the deployment of the AI-based SurakshaNet system by the state of Himachal Pradesh violates fundamental rights guaranteed under Articles 14, 19, and 21 of the Constitution. Your Lordship, the third issue being whether algorithmic decisions made using anonymized but re-identifiable data attract liability under the Digital Personal Data Protection Act of 2023, and whether private AI entities performing public functions are subject to the constitutional scrutiny, Your Lordship. Your Lordship, the council will be dealing with the first and the second issue and would be arguing for 23 minutes, and my co-counsel will be dealing with the third issue and would be arguing for the 22 minutes. Your Lordship, the council seeks permission to proceed with the pleadings.
Yes, you may counsel.
Much obliged, Your Lordship. Your Lordship, the first issue before this Honorable Court is whether the PIL filed by the petitioner is maintainable under Article 32 of the Constitution of Bharatavarsha. Your Lordship, the Council humbly submits that this issue may be answered in affirmative, and the petitioner seeks to establish the maintainability of the present petition on 3 grounds. Your Lordship, the Council seeks permission to proceed with the 3 grounds.
Yes, you may.
Much obliged, Your Lordship. Your Lordship, the first ground being that there is violations of Article of the fundamental rights attracting Article 32, Your Lordship. Your Lordship, Article 32 of the Constitution is itself a fundamental right, and it guarantees the right to move to this honorable court for the enforcement of the fundamental rights conferred by the Part 3. Your Lordship,
Council, is Article 32 a fundamental right, or does it empower to move to the court to enforce fundamental rights?
Your Lordship, Article 32 itself is a fundamental right as it is held on in the Sri Bodhisattva Gautam case versus the Miss Shubhra Chakravarti case, that Article 32 itself is a fundamental right, Your Lordship.
Yeah, proceed, Council.
Much obliged, Your Lordship. Your Lordship, in the present case, the use of the AI-based predictive policing system, the said system, that is the SurakshaNet, has caused ongoing violations of Article 14, 19, and 21. Your Lordship, this impacts not only the individual but the society at large. Your Lordship, this Honorable Court has consistently held that where fundamental rights are infringed, this court not only has the power but also the constitutional obligation to intervene. Therefore, the present petition falls squarely within the scope of Article 32, Your Lordship. Your Lordship, the Council seeks permission to proceed with the second ground.
Council, but you just said that there's a violation of Article 14, 19, and 21.
Indeed,
What
Your
makes you
Lordship.
say that there's a violation of these articles?
Indeed, Your Lordship, the Council states that it is humbly submitted that there is violations of Article 14, 19, and 21 as there is arbitrariness caused. And article for the intelligible differentia, there is no intelligible differentia, no rational nexus, your lordship, and there is no statutory backing as well, because there is administrative discrimination, your lordship. And article 19, when it comes to article 19, the said selection and system creates a chilling effect on the citizens, your lordship. And there are ongoing violations of article 19 clause 1 clause d as well, your lordship. And Article 21, the main components of this article, your lordship, are the right to privacy, right to dignity, and right to for the procedure established by law, due procedure to follow due procedure established by law. And the said selection and system fails eminently, your lordship, because none of these is being followed, nor the case nor the test founded in the case Puttaswamy versus Union of India is being followed, your lordship.
But what is the basis of these legal arguments you make in? What is the factual basis?
Indeed, your lordship, the council humbly submits that the said system is the selection and system is targeting the individuals on the facial recognition potential as potential disruptors and risk profiling and detention, your lordship. Your lordship, it can be seen that the selection system is itself vague, your lordship, because here it is nowhere defined who is being targeted and on what criteria, your lordship, and what are the consequences, your lordship. It leaves the citizens to guess and even the authorities to decide the will.
Counsel, you justify the locus standi first.
Much obliged, your ladyship. Your lordship, that is my second ground. So proceeding to the second ground of the first issue, your lordship, it is humbly submitted that the present petition satisfies the liberalized doctrine of locus standi applicable to the PIL, and the petition is filed bona fide and in genuine public interest. Your lordship, the council seeks the attention of the bench to page number 12 of the memorial and para number 4, as it is said in the SP Gupta versus Union of India case, that it was held that in the matters involving enforcement of the fundamental rights, any public spirited individual or organization may approach the court, particularly where the affected person are unable to do themselves and due to social, economic, or structural barriers, your lordship. Lordship, in the present case, the deployment of the AI-based predictive policing system directly that directly affects the students, activists, and the marginalized community, your lordship. And these individuals are being disproportionately subjected to the surveillance, profiling, and detention, your lordship. And the affected individuals are realistically incapable of individually challenging to the state, which is backed by the technological surveillance before this honorable court, your lordship. And furthermore, the council submits that the petition is filed bona fide and in genuine public interest. Your lordship, there is no personal or political or oblique motive, and this aligns with the judgments and the principles proposed in the Bandhuwa Mukti Morcha versus Union of India and Sheila Barse versus Union of India, and thus the present petition possesses the requisite standing to maintain the present petition, your lordship. Your lordship, proceeding to the third ground, if the objections based on the policy expertise or internal security do not affect the maintainability under Article 32, your lordship, because this honorable court has consistently held that when the fundamental rights are involved, neither the policy discretion or nor the technological complexity can be exclude the judicial review. Your lordship, in the famous case of case Puttaswamy versus Union of India, in this case, your lordship, a highly complex technological system was examined, and it was reaffirmed that the constitutional rights cannot be overridden by the executive policy choices. Your lordship, in the similar case of PUCL versus Anuradha Basin versus Union of India, this honorable court has held that national security claims cannot be asserted in abstract. That is, mere claims of efficiency or security cannot defeat the constitutional scrutiny, your lordship. Therefore, the the court has held that national security claims cannot be asserted in abstract and must satisfy the test of legality, necessity, and proportionality, your lordship. Your lordship, if the bench is satisfied with the arguments of the first issue, the council seeks permission to address the second issue.
No. Kindly please answer that your student organization has a statutory mandate to be treated as PIL?
Indeed, your lordship, the council begs to differ here. That is, your lordship, the clients that we are representing on the basis of the public interest litigation. That is, the public's interest is being involved, Your Lordship, here. And we are taking Raghav Menon as an example. That is, he is the beginning of the violation of the said system, Your Lordship.
So would your position change if Raghav Menon himself had not been detained but only flagged by the algorithm?
Pardon, Your Lordship. Your Lordship, indeed not, because the council begs to differ that even though if Raghav Menon was being detained or not, the said system would go on violating the Articles 14, 19, and 21, as to there is risk to the fundamental rights, Your Lordship.
So, all right, now let me please know what specific legal injury was suffered by this your company, Tech Justice Collective?
Pardon, Your Lordship. Can I? You're not audible properly.
What is the legal injury that is being caused to your company, Tech Justice Collective?
Your Lordship, the PIL.
This I'm
Your Lordship,
asking
there.
of locus
Indeed. Indeed. Your Lordship, it was held in the case of SP Gupta and versus Union of India that a person or the individual organization can go can represent the other people. There is no necessity of personal injury, Your Lordship. Your Lordship, PIL is a exceptional jurisdiction, and here there is no need of personal injury, Your Lordship. That is that would be my contention, Your Lordship.
Then Raghav Menon. Now, would your position change if Raghav Menon himself had not been detained?
No, Your Lordship, we would still be here for contesting the public, because public interest, the public at large is being affected, Your Lordship, here.
All right. So all the 3 points, injury is not being caused. Raghav Menon is not a personal cause, and then the organization, student organization, that is not having a statutory mandate. Then how are you justifying the locus standi?
Your Lordship, because we are here in the public interest. Your Lordship, give me a second so that I can. This moment. Your Lordship, we are here on behalf of the public because we have genuine public interest. Your Lordship, in the case of in one of the landmark cases, it was held that the prima facie test of the PIL is there should be bona fide interest and should bona fide intent and the genuine public interest. And Your Lordship, we are satisfying this prima facie test, Your Lordship.
Carry on, please. Go ahead.
Much obliged, Your Lordship. Your Lordship, due to the paucity of time, I would like to go briefing the main points. Your Lordship, the second issue before this honorable bench is that there is violations of Article 14, 19, and 21. Your Lordship, am I audible?
Yes, you are.
Indeed, Your Lordship. Your Lordship, there is violation of Article 14 because Your Lordship, Article 14 directly strikes at arbitrariness. And in the present case, it can be seen that Surakshan Act itself is unconstitutional and it manifests arbitrariness. Your Lordship, firstly, there is no statutory backing or there is no statutory authority governing its deployment. As this whole Surakshan Act is operated purely through executive directions and private technological arrangements. Your Lordship, as it was held in the famous case of Menka Gandhi versus Union of India, any procedure affecting the personal liberty must be just, fair, and reasonable. And such fairness necessarily presupposes the existence of law. Your Lordship, the current system, the Suraksha Net system, fails this test, Your Lordship. Secondly, the system relies on vague and indeterminate standards such as potential disruptor and behavioral risk. Your Lordship, these words are nowhere being defined, nor in the DPDP Act, nor in the General Clauses Act, or any of the statutes or any of the law defines these. So these terms are vague, Your Lordship. And in the case of Shaira Banu versus Union of India, this court has held that vagueness and uncanalized discretion amounts to manifest arbitrariness. Your Lordship, the said system here fully satisfies these two contentions, Your Lordship. Your Lordship, thirdly, the Surakshan Act fails the reasonable classification test as laid down in the Ramakrishna Dalmia versus Justice Tendolkar case. Your Lordship, there is no intelligible difference here, or no rational nexus with the objective that is claimed to be sought, Your Lordship. Then nextly, Your Lordship, the detention of Raghav Menon, a student who has no criminal background, solely on the algorithmic suspicion, demonstrate that there is arbitrariness in the application, Your Lordship. Finally, Your Lordship, it is further submitted that AK Kripak in the case of AK Kripak versus Union of India, this court has held that even administrative actions must adhere to the principles of natural justice. Your Lordship, in the present case, Suraksha Net provides no notice, no review, no hearing, no reasons. And after all, Your Lordship, there is no appeal mechanism itself. And this is a grave violation of the principles of natural justice and especially odi alteram partem, Your Lordship. With these foregoing grounds, I would like to submit that the Suraksha Act violates Article 14. Your Lordship, proceeding to the second ground, that there is violation of Article 19 because it creates a chilling effect and disproportionate restrictions on the individuals. Your Lordship, activists and these individuals may be discouraged from expressing themselves freely out of fear of being targeted by the state. Your Lordship, this stifles the public discourse, which is fundamental aspect of the democracy. Your Lordship, under Article, Your Lordship, it is rightly said that Article 19 is not absolute, but the restrictions posed must be reasonable. Your Lordship, Article 19 clause 1 clause A, under this clause, the continuous monitoring of the online activity and behavioral data creates a chilling effect on the free speech. Your Lordship, in the landmark case of Shreya Singhal versus Union of India, it was held that any measure that induces self censorship.
You mean to say surveillance is equal to restriction?
Your Lordship,
You mean to
pardon?
say surveillance is equal to restriction?
Indeed, Your Lordship, because under the Article 19 clause 2, it mandates that the restrictions must be imposed by law. Suraksha Act here lacks legislative backing and therefore fails a legality requirement test, which was reaffirmed in the case of K.S. Puttaswamy versus Union of India. Your Lordship, moreover, Article 19 clause 1 clause D, it states that it can be said that algorithmic flagging directly leads to restrictions on the movement and detention, Your Lordship, because in the case of Menka Gandhi, this honorable court has held that restrictions on movement must follow a fair, just, and reasonable procedure. Your Lordship, the restrictions here fail to prove or fail at the very prima facie, Your Lordship. Here, if the bench is satisfied with the answer,
Argument will be same if surveillance is targeted some violent extremism.
Your Lordship, pardon, please.
This surveillance, which you are treating as restriction, is now only monitoring the social media. Am I right?
No, Your Lordship, because indeed not, Your Lordship. The council begs to differ because here the only surveillance is not on the online activity but also the behavioral data, Your Lordship. The facial recognition is being captured. Even there is Aadhaar link data being collected, Your Lordship. Therefore, this creates a mosaic effect, Your Lordship. That would be my contention.
The monitoring is online only, no? The monitoring is the face and algorithm all are being detected online social media platforms only, no?
Indeed, Your Lordship. It is being collected online only as per the facts which has been proposed by the Moot proposition. They have given only online data is being collected, Your Lordship.
Right? So your argument would have been same if this surveillance has been on some violent or some terrorist attack or so. Like this act is only to monitor just as a precautionary measure that let not something big happen.
Indeed, Your Lordship. Your Lordship, the council begs to differ.
Yes.
Indeed, Your Lordship, but in the case of Anuradha Basin versus Union of India, this honorable court has held that the national security claims cannot be asserted in abstract, Your Lordship. Even though the restrictions are put for the precautionary measures, it should satisfy that there is the just, reasonable, and fair procedure, Your Lordship, and it should comply with the legality requirement, Your Lordship.
So, all right. You are here to
Therefore, the mayor claims.
You are here because you are aggrieved by the arrest of Raghav Menon. All right? And because of this, you are saying that entire act which has come into existence is wrong because one person is arrested. Right?
Indeed, not, Your Lordship. The council begs to differ here because, Your Lordship, it can be seen that Menon is just the beginning of the target that the Suraksha Net has been. This affects the whole public, Your Lordship. In the coming days, Your Lordship, the question is not the policy wisdom, but the constitutional violation that follows the Suraksha Net system,
Go
Your
ahead,
Lordship.
please. Go
Much
ahead.
obliged, Your Lordship. Your Lordship, due to the positive thing, Your Lordship, there is coming back to the Article 19, Your Lordship, in the case of Damayanti Naranga versus Union of India, the court recognized that the freedoms of the association includes autonomy or participation, which is undermined when individuals fear algorithmic profiling. Your Lordship, in the present case, Suraksha Net imposes disproportionate and constitutional restrictions under Article 19. Your Lordship, there is violation of Article 21, that is the main limbs of this article, that is Article 20, that is privacy, dignity, and due process are not being followed. Your Lordship, the very at the primary stage, the set selection system fails the four-limb test of the which is given in the case Puttaswamy versus Union of India. That is, there is no law, there is no demonstrated necessity, Your Lordship. As the system targets the general population, there is no proportionality since less intrusive alternatives are ignored, and there is no procedural safeguards because the oversight. Due to oversight and accountability, Your Lordship, because in this case the court had held that the right to privacy is the fundamental right under Article 21. Lordship, further, in the case of Francis Mullen versus Union Territory of Delhi, the court has held that the right to life includes the right to live with dignity. Lordship, branding the individuals as potential disruptors, which is nowhere being defined. This causes, like only on the purely on the algorithmic predictions, it uh, it strips the dignity and autonomy and reducing the human beings to mere data points, Your Lordship. Your Lordship, additionally, in the case of Menka Gandhi, this court has held that any deprivation of liberty must follow a fair and
See,
just
let's keep all the previous cases aside. Let us come on
much
to the point that don't fear about time, right? Let us discuss one thing here. That
indeed, Your Lordship.
you are aware that when we scroll the reels or when we keep on searching something to purchase online, right? The algorithms are measured and we get come to the same types of advertisement again and again. Do you agree? Do you agree? Suppose
Indeed, Your
I'm
Lordship.
on Instagram and I want to purchase some moisturizer. All right. So I searched or I am
Indeed, Your Lordship.
searching some particular type of moisturizer. The algorithm of my eyes, my facial expression are being caught, and that is very rightly being captured. All right. That is why again and again I'm getting the advertisement of some moisturizer only. Right. So
Indeed, Your Lordship.
why can't in this case this also be true that let it be that Raghav Menon does not have any criminal record, previous criminal record, but the algorithm might be correct and he might have some intentions to do wrong. So how can the entire act be you feel that this is endangering the privacy of people?
Indeed, not, Your
Because
Lordship.
AI
The
is much advanced. AI is much advanced now, right?
Indeed, Your Lordship. I agree with that. Indeed, Your Lordship, before for the question post, the council makes a difference here because Your Lordship, as you said, with the analogy of the Instagram post, what you had told, Your Lordship, if there are two citizens posting identical content, Your Lordship, there arises a question that can the algorithm treat them differently or on what basis, Your Lordship? This arises a question on part of the users, Your Lordship. And one more thing is that if the state cannot explain the moderate bias or the model's bias itself, then how can the citizens trust its neutrality, Your Lordship?
Me, how the state is not expressing, how the state is expressing biasness?
Your Lordship, because here Your Lordship, the set system is brought by the government. It is if we take into consideration that this is brought by the government, and there this is Your Lordship, there is one more thing that the proposition is silent on the fact that there is human intervention or no. further human intervention or no. And also, if we take it in a positive manner that there are human interventions, then this is the political motive of the government itself, Your Lordship. This would be my contention, Your Lordship. And it depends on the data, Your Lordship, the users take or post, Your Lordship. That is my contention, Your Lordship.
All right.
Much obliged, Your Lordship. The council seeks permission for an extension of 1 minute to sum up the issue.
Yes, please. Granted.
Much obliged, Your Lordship. Your Lordship, the said system under Article 21, it lacks transparency. Its reliance on the potential inaccurate data and the absence of the mechanisms for appeal or independent audit pose a threat to the personal freedoms, Your Lordship, and hence it violates Article 21. Your Lordship, in summary of this second issue, I would like to state that the said selection system violates Article 14, 19, and 21 as it is unconstitutional, arbitrary, discriminatory, and does not follow the due process established by the law, Your Lordship. The council, if the bench is satisfied with the arguments of the second issue, the council seeks permission to proceed the third issue by my co-counsel.
Yes, advocate.
Yes, you may.
Benches agree?
Yes, ma'am.
Benches agreed on it?
Yeah, definitely. Sure.
Much obliged, Your Lordship. It was an honor to argue before Your Lordship.
Your Lordships, am I clearly visible and audible?
There's an echo speaker too.
Yes, it is.
Am I clear now, Your Lordships?
Yes, you're clear.
Yes. I request the permission of the Honorable Bench to proceed with issue number 3 in 2 different dimensions.
Yes, you may.
Yes, much obliged, Your Lordship. I will be addressing issue number 3 in 2 different directions as to whether algorithmic decisions made using anonymized but re-identifiable data attract liability under the Digital Personal Data Protection Act, which hereinafter shall be referred to as the DPDP Act, and whether private AI entities performing public functions are subject to constitutional scrutiny. The council humbly submits that SurakshaNet processes anonymized but re-identifiable data, which definitely constitute as personal data under the DPTP Act. It does not derive consent, free and legal consent, and the way it is processing the said data is rather opaque. And further, it also permits private AI-based entities to perform core sovereign functions, which is of policing and surveillance, and therefore fall into the purview of the meaning of the term state as provided for under Article 12 of the Constitution, and therefore do need to be scrutinized in view of the Constitution. I'll be addressing the first issue first. The respondents repeatedly claim that SurakshaNet relies on anonymized data, and both in terms of the fact and the law, this claim is untenable. Because the DPDP Act, as under Section 2, Subclause T, defines personal data as any data relating to an individual who is identifiable by or in relation to such data. The fact that Raghav Menon's account was flagged by the algorithm and the fact that he could be clearly identified by such an algorithmic decision and detained in preventive or otherwise by the said state clearly shows us that this data is very much reliable and it does constitute personal data as provided for under the DPDP Act. It clearly, in terms of the Puttaswamy judgment, which this honorable court itself has adjudged, it does not fulfill the triple test criteria. While the Puttaswamy judgment did agree on the fact that the right to privacy is not absolute and exemptions to the said right and limitations can be set on the same, a triple test was laid down in the same. What it requires said action to be fulfilled is that there must be legality, there must be an aim of the state, and third, it must be proportional. While there is a law backing the said action here, which is the DPDP Act, and there is an aim of the state, which is to enhance the public welfare and public administration of it. The legitimacy, the lawfulness and the legitimacy of the state aim can definitely be questioned on several grounds, both logical and legal, which I would like to proceed with. The fact lies in another stipulation laid down in the Puttaswamy judgment itself. It is what is called as the mosaic effect. The Kutaswamy judgment provides that while individual aspects of data, when collected by themselves, is may not inherently lead to a person being identified or lead to their profiling. However, as the DPDP Act clearly provides, when all of these are aggregated together, they might very much enable an entire profile of an individual to be created. And as a result of this profile, anonymized data can be used for re-identification, which is very obvious in Raghav Menon's case, leading to the kind of detention which did not have. Another stipulation laid down under the DPDP bill is while algorithmic decisions will be used to enhance the efficiency of policing and law and order functions, it must be taken into consideration that while the act claims to collect such data on basis of an individual's consent, I would urge the honorable court to take into consideration section 7 of the DPDP Act, which provides for what consent may be used for, and when consent may not necessarily be taken from the said individual, which is the data principle, the individual whose data is being processed. Now, with several clauses of Section 7 lay down legitimate reasons as to why an individual's consent may not necessarily be taken, which is during medical emergencies during epidemics, outbreaks, and diseases, and ensuring an individual's safety during a public order breakdown or a disaster. And for the purpose of addressing the safeguarding of employees. However, coming to clauses A and B is where I believe serious aspersions are cast upon the intent of the said state as to why they are being doing this. Now, it provides that a data principle is required to voluntarily give consent to data being processed. However, it provides that in once such data has been provided, unless the data principle deliberately and explicitly states that my data does not, or I do not permit my data to be used in a certain way, it is assumed that once collected, the data can be used for what the state believes or stipulates is a legitimate purpose to be fulfilled under the law. Now, it further goes on in clause B to say that the state or its instrumentalities may use data principles, personal data, in terms of providing some kind of data, service, license, or permit, seemingly legitimate uses. And consent may not be taken in the said case. It
Counsel,
also deals with another interesting dimension.
Counsel, could you just hold on? With all these statements, what is the conclusion that you're trying to draw the court's attention to?
Please give me a few seconds, Your Lordship.
It's a wonderfully memorized piece. What is the conclusion that you want us to come to?
Sir, Your Lordship, apologies. I would like to address the fact that algorithmic decisions firstly cannot be relied upon, and as the facts of the state of the case clearly provide that an algorithm flagged Mr. Raghav Menon as being a potential disruptor, a term which has not been defined anywhere, and the fact that there is no human intervention before the preventive detention even took place, which is violative of Article 22 of the Constitution of Bharatvarsha, which clearly provides that if anybody is taken into custody, preventively detained, they must be informed as to what grounds they are detained on. They must have access to legal aid, and the period of such detention cannot exceed, I believe, a certain fixed duration, after which a said board needs to intervene to let the preventive detention continue.
So your main argument is that the AI feature is wrong and it's arbitrary. That's what you're trying to say.
Yes, sir. And why I believe that the AI feature could be misused is bringing to attention how an AI-based algorithmic system is trained in itself. So when we talk about algorithmic decisions being made, an algorithm is a decision when we train an AI tool to do a certain task, that is based off on the fact that data sets based off of human behavior are given access to the said thing, and depending on the kind of data of human behavior the system has access to is what it will base its decisions upon, because ultimately AI does mimic human behavior. So the kind of data set it has access to is what it will base its decisions upon, and since we have no knowledge as to what kind of data sets it has access to, We may very well say that it may be trained to function in a certain manner, which shows that there is a certain degree of arbitrariness to
So
the
your
same.
entire petition is speculative in nature, right? That it can happen. That's what you're saying.
No, sir. No, Your Lordship. The I beg to differ.
You
Could I
just
have a
said
few
that the
seconds of
data
time?
sets may be trained in a particular way. You said that, counsel.
Yes, Your Lordship, I beg to differ. Now, while the AI mission aims to enhance public welfare, uphold law and order, etc., what the state believes to be harmful or a threat to the sovereignty or integrity of the nation very much depends on what the state believes to be
That is
there.
what the laws are for. That's exactly what the laws are for. You would basically agree that Raghav Menon was detained. So instead of going to a criminal quashing case, you filed a PIL over here.
Yes, sir. But the fact also lies in the fact that in case of Mr. Raghav Menon, he has been preventively detained merely on what an algorithm has been said, and
That's
there was
exactly
no
what my
human
point is,
oversight
counsel.
involved at all.
You're agreed that Raghav Menon was detained, and you advised your client wrongly that you come to the Supreme Court instead of approaching the lower courts and file a quashing.
So sorry, I don't follow your question. Could you please repeat?
You are basically aggrieved that Raghav Menon was detained, and you should have gone for getting his bail or getting a quashing. Instead of doing that, you filed a PIL over here. And your entire PIL is speculative in nature as per your own arguments, as per your own contention that the data sets may be trained in a particular manner.
The right
Yes, so going back to section 7 of the DPDP, it clearly shows that the consent of the data principle is not entirely free consent, which shows that there is some kind of intent behind the said legislation that they're seeking to achieve. The fact that you are assuming consent which has been given once to be used for what the state deems legitimate, but it is silent on the fact that once such data has been accessed, what will be done with the data? It does not provide for the fact that once the state uses data given by the principal for the provision of such legitimate uses, what will be done with the data? It is silent on that fact. And if it were that legitimate of a usage, it should have been erased or not been accessed by the state once such purpose was fulfilled. It talks that it will use it for a legitimate uses, but does not address what it will be done when such legitimate use has been made.
So you're not aggrieved by the law. You want the court to fill the lacuna and act as a legislative power to fill to complete the law, right? That's what you're saying.
So what I mean here is that a person merely on the basis of an algorithmic decision is being detained for reasons which are not defined anywhere, and which clearly shows us that there is a violation of his fundamental right. And since Article 32 in itself is a fundamental right, we, on behalf of Raghav Menon or as public spirited individuals, have all the right to go and approach the court to review policies or laws which are giving rise to such situations.
You may
So
proceed
what
with the argument.
incident is attracting 32?
Ma'am, you're not audible. Apologies.
What you are arguing is you are giving the reason of maintainability of 32 is that the arrest of one person on the basis of algorithm, right? So the co-judge is saying the same thing, that you are aggrieved by the fact which is attracting a criminal case. And you have alternative remedies for that instead of coming on to for 32. Why you directly approach to Supreme Court?
Ma'am, the Constitution of the Union of Bharatavarsha itself clearly stipulates that Article 32 itself is a fundamental right. And
All right, understood. That also understood for your sake, right? Then is there a violation of fundamental right if a person is arrested?
ma'am, you weren't audible. Apologies.
If one person is arrested only on the basis of one arrest, and that also a preventive detention, can the entire law be challenged?
Yes, very much, Your Lordship. Your Lordship.
32.
Yes, because since it's a fundamental right in itself, and any kind of violation of fundamental rights, we may be able to approach the Supreme Court for the same. And as held in.
So for all the detention under any law, you will come directly to Supreme Court?
Yes. Ma'am, I'll address this in 2 points.
Yes.
First, the fact that there is merely because there's an alternative remedy present It does not, as held in the Srimant Patil versus Karnataka Legislative Assembly case, that merely because an alternative remedy exists, it does not bar anybody
What was
from approaching the Supreme Court.
the facts of this case you are citing? Can you
Apologies, ma'am.
can you mention the facts of the case?
Ma'am, yes. Ma'am, please give me a moment. Apologies.
All right, let us leave it. It will take time otherwise. The facts of the case you are addressing and the facts of your case are totally different. All right?
Ma'am, yes, ma'am, I beg to differ.
Please go ahead.
Yes, ma'am. Ma'am, we are a student-led research organization who believes that Raghav Menon has suffered an actual injury to his fundamental rights because on very, very vaguely defined grounds, he has been detained. And we believe that merely because there is one violation of fundamental rights doesn't bar us from approaching the court for the same. And mere presence of an alternative remedy also does not bar us from approaching the court. And the fact that an AI entity, which may be depending on the way it is trained, and it does not comply with the fact that the DPDP bill stipulates that if there is any kind of AI algorithm being put in place, there will be human oversight in the picture. The proposition in itself is silent on the fact whether such preventive detention took place after there was human oversight involved in the picture. The proposition itself stipulates that the algorithm flagged him as a potential disruptor, and then he was taken into preventive detention. It is silent on whether there was any human oversight or not, which brings us into questioning as to whether this kind of algorithmic decision making is a sound thing to involve into policy.
Okay, go ahead with your next argument.
It is further submitted, Your Honor, that algorithmic outputs directly affect an individual's liberty. And therefore, when such kind of fundamental right is at stake, it shows that legal responsibility, both on the state and the said entities they are involving, is heightened. The fact that he was solely detained on these algorithmic other attests to the said fact that I'm mentioning. Thereby, we would urge the court to consider holding both the private AI entities involved, as since it is performing the core policing function of the state, as provided for under Article 12, and hold both the state and the private AI entities involved accountable for such harmful processing of data. Also, while an important point was raised as to whether my argument about the possibility of harm arising is merely speculative in nature, there was an important test laid down in the Ajay Hasia versus Khalid Mujid case, which talks about the functional and control based test. While the respondents assert that there is mere technical output taken from the private AI entities involved, we also need to understand that the fact that the DPDP bill permits these said AI entities to store these kind of data collected outside the territory of India shows that the AI entity does have a exercise autonomy over the way in which it will be processed, how it will be stored offshore, and thereby we cannot even really question as to what can be done once this data is stored offshore, which is what it brings. So in context of this, as per the functional and control based test laid, once the private entities involved are given this degree of autonomy in terms of storage and processing, it casts serious aspersions as to whether it's merely a processing entity because it is having this degree of autonomy involved. And as held in the R.D. Shetty versus International Airport Authority case, any kind of bodies, private, including the private bodies, discharging public functions are bound by the constitutional mandate. And in saying this, I would link it to the issue raised itself, is whether such entities are required to withstand constitutional scrutiny. Absolutely.
Yeah, this answer to question. You're answering the questions.
Yes. Coming to the A.K. Roy case, versus the Union of India. This honorable court has held that powers affecting liberty, such as preventive detention, are inherently sovereign functions and may be exercised only on the strict constitutional and statutory control, which clearly is not being seen in the case of in this case which we are making. And since this kind of autonomy to a private entity which is processing our data is given, legislation here in case is excessively delegated and therefore can be deemed to be is deemed to be ultra virus of the said act. I request the permission of the council to of the honorable court to summarize my arguments.
Before that, I would like to again ask, how have you connected Ajay Hasia versus Khalid Musi with this case?
Your ladyship, you are not audible.
Am I now?
Yes, you are.
I would like to know the two cases you have referred here, precedents, Ajay Hasia versus Khalid Musib and International Airport case. How these both cases are connected with your argument now?
Yes. The private AI entities involved seek to absolve themselves of liability under the DPDP Act. They say that merely they were involved in giving the technical inputs with relation to the Suraksha.net system. However, Article 12 of the Constitution expressly provides that private bodies, when they are discharging functions of the state, are also considered state within the meaning of Article 12, clearly providing that they will need to be scrutinized in lieu of the Constitution. And while the claim on which the entities seek to absolve themselves of liability is that they were merely giving technical input. However, in context of the Ajay Hasia case, the functional and control based test is what we are going to be applying here. The fact that they are allowed to are permitted to process this kind of data, store it out offshore, shows us that they do have a lot of autonomy and control over the data that they are processing. And in Adi Shetty versus the International Airport Authority, I cited the same because given the fact that they exercise this much control and autonomy of the state, they fall under the definition of state as provided for under Article 12 and therefore are therefore bound by the constitutional mandate which they are subjected.
So the companies you are wanting to say they are working as a state agency.
Your ladyship, you are not audible again.
Am I now?
Yes, your ladyship.
So you want to say the companies dealing with this algorithm, they are falling under state?
Yes, your ladyship.
All right. Right. Go ahead, please.
Yes, your ladyship, I request your permission to conclude this thing.
Yes.
I humbly submit that given the nature of the control the private AI entities here involved exercise, and also the fact that algorithmic decisions cannot be entirely revolved upon. In the present case, in the present case, since the delegation is ultra virus, the states, the private entities involved are exercising a great deal of autonomy over the data which has been collected, and the fact that the mechanisms in place are very opaque, cannot be reviewed, and the DPDP Act itself does not provide for any kind of review and audit mechanism, shows us that while the aim of the policy may be to enhance efficiency, it makes us wonder as to whether this is actually being done or we are turning slowly and very pervasively into a police state. In Menaka Gandhi versus Union of India and the K.S. Puttaswamy judgment, this honorable court held that interference with life or liberty needs to be just, fair, and reasonable, and subject to meaningful review of the court. And in the said case, there is a large failure of these standards. That is how I would summarize my. I request the permission of the honorable bench to proceed with the prayer.
Yes, ma'am.
Could I proceed with the prayer, honorable bench? Much obliged. In the light of the facts, issues, and arguments advanced and authority cited, we humbly and respectfully pray that this court will please adjudge the deployment of Suraksha Net as unconstitutional and violative of fundamental rights. Issue an appropriate writ order or direction directing the respondents to suspend the operation of the said same before these concerns are addressed, and declare that the collection of and processing of personal data is illegal and violative of the DPDP Act, and any AI and private entities performing core sovereign functions are state within the meaning of Article 12 and are bound by constitutional obligations. To grant any relief this court sees fit in favor of the petitioner in interest of justice, equity, and good conscience. All of which is humbly and respectfully submitted. Much obliged, Honorable Bench.
Right. We will move for the arguments of respondent, please.
Uh, am I audible?
Yes, you are.
Yes.
Before we start the round, I just want to state something to the court master that my speaker number two was having some emergency. That's why she was not here, but she'll be joining in a while. So my researcher would be just the researcher, while my speaker two will continue with issue two.
So before we are moving ahead with your round, your speaker to have to join. She have to be available.
Yeah, she is available. She's just joining the meeting.
Okay. All right. If judges may allow that.
Yes.
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 Thank you.
But we'll be treating your researcher also will be treating as speaker.
All right, ma'am.
Right?
All right. The council seeks permission to approach the dais.
Yes.
Much obliged. The council seeks permission to approach the bench as my lords.
Yeah.
Much obliged. May it please this honorable court, I appear here on behalf of the respondents, the Union of Bharatvarsha, the state of Himachal Pradesh, and the impleaded private respondents. With your lordship's permission, I rise to address the issue 1, namely whether the public interest litigation filed by Tech Justice Collective is maintainable under Article 32 of the Constitution of Bharatvarsha. If my lords are well versed with the facts, I'll start with my arguments.
Yes, please.
Much obliged, my lords. So, at the very outset, my lord, I submit with the greatest respect that this issue goes to the root of the court's jurisdiction. If the petition is not maintainable, the court cannot travel into merits regardless of the seriousness of allegations. Jurisdiction cannot be created by apprehension. Article 32 is invoked only by violation. So, why the facts are crucial at maintainability stage? My lord, maintainability under Article 32 is not decided in abstraction. It is decided by examining what record actually discloses. So, if I check the moot proposition, the fact sheet of the moot proposition and the respondent's memorial also, as recorded in paragraph 1 of the moot proposition, the Republic of Bharatvarsha adopted the National AI Mission 2023 with the express objective of integrating AI into public administration, policing, and governance. Also, pursuant to this national policy, as recorded in paragraph number 2 of the moot proposition, the state of Himachal Pradesh launched SurakshaNet in December 2024, an AI assisted predictive policing system. These facts are reiterated without dispute in respondent's memorial. Statement of facts, again in page 8 to 9, paragraph number 2 to 4. Now, my lords, what SurakshaNet does and what it does not do becomes decisive. The nature of SurakshaNet as established on record is it clearly stated that SurakshaNet does not have a statutory authority. It does not arrest, it does not detain, it does not prosecute, it does not issue binding or coercive orders. Its function is limited to analyzing large data sets, identifying patterns, and also generating non-binding alerts. The final decision-making authority always remains with human police officers acting under statutory safeguards, particularly the Code of Criminal Procedure.
Where is it mentioned? Is it mentioned in proposition? Human intervention?
My lord, this is mentioned in the respondent's memorial, paragraph number 5 to 7, page 14 and 15.
No. So you are not referring to the proposition. They themselves have stated here that human intervention proposition is silent on it.
Ma'am, my lord, that will be substantiated in my further arguments.
All right.
Much obliged, my lord. Uh, this factual position is not denied by the petitioners, and my lord, this distinction is critical because Article 32 is concerned with coercive state action and not advisory tools. What the petitioners actually rely upon is when the pleadings are stripped of rhetoric, my lord, the petitioner rely on solitary incident, as recorded in paragraph 4 of the moot proposition and acknowledged in respondent's memorial, paragraph number 7 in page 15, that a student, Raghav Menon, was detained after being flagged as a potential disruptor. However, it is crucial that the detention was executed by human police officers under existing statutory powers, not by any algorithmic mandate. There is no pleading that Surakshanet ordered the detention or police discretion was eliminated, or also statutory safeguards were bypassed. Thus, the alleged injury does not flow from Surakshanet itself. The factual break in causation is fatal for Article 32. And Article 32 is remedial and it is not advisory in nature. My lord, Article 32 has been described as the heart and soul of the Constitution, but its scope is precise and limited. As it was reiterated in the case of Darayo versus State of Uttar Pradesh, held by a constitutional bench, the court held that Article 32 is not an appellate or supervisory jurisdiction. It can be invoked only when there is a clear existing violation of fundamental right, and it cannot be used for speculative or hypothetical grievances. This principle is relied upon in the respondent's memorial, paragraph number 1 to 3, that is in page 13 to 14.
So how are you enhancing the argument that this is speculative? When a person has been arrested just on the basis of algorithm, how you can say that it is not affecting public at large? So state on the basis of this act will pick anyone.
My lord, the mere arrest of a single person without any proof of arresting or detaining or prosecuting any other person, it seems to be more like a private interest litigation than a public interest litigation.
So, but act is also not very clear on it, na? Act is not very clear.
Ma'am, your lord, my lord, the act might not be very clear, but on the contrary, no such information have been provided regarding other persons also getting arrested or falsely imprisoned.
So let us not consider arrest of a person. Let us only take into consideration the act. The act which is giving an indication that state can use their malified intentions also on the basis of this act. And this act can be a good tool for a state to act malifiedly against the persons whom they do not like. Right? So where the PIL is wrong then?
My lord, as I've already mentioned, PIL here, which we talk about, is of the public at large. But currently, the
Public at
arrest.
large will be affected through
What?
through this act. Not we are not considering here the arrest of one single person. If this act will be implemented in such a manner, this is going to affect public at large.
Uh, my lord, what might happen is the concept of what might happen seems to be very much speculative in nature.
No. This is not very hypothetical. Only on the basis of AI algorithm, people are arrested, not one single person. There may be hundreds of other people too. They will be arrested without checking the criminal record, without having any solid proof against them. So why not this act must be challenged? And if one has to challenge an act, where they must go other than 32?
My lord, counsel will get back to you regarding that.
All
If I
right.
may proceed with my argument.
Yes, please.
Indeed. Uh, my lord, again in Romesh Thappar's case, which was also another constitutional bench judgment, There, the court held that Article 32 is meant for is not meant for abstract constitutional review, but strictly for enforcement of rights actually infringed. So, my lord, what might happen uh, in the future is not of our concern right now, as the Article 32 allows only enforcement of rights which are actually infringed. That is infringement of the current right which has been.
Counsel, this is the exact question which ma'am asked you. This is the exact question. You said you'll answer later, but you're again going with the same statements that you were making. One person has been arrested based on a policy that you made, based on an act that you made. You say the act might be wrong. Do you admit the act might be wrong?
Indeed not.
Okay. So basically, on the basis of an act, which is a very wonderfully drafted act, one person has been detained. All right. So we're not speculative over here. We're not being speculative. There is someone in jail right now. So what is your statement on that?
If I'm applying the case which I cited just now to my present case, there was no existing violation which is demonstrated. The petitioners challenged the possibility of the misuse. And
Over here, the possibility has taken place. Should we wait for all of us to be arrested?
my lord, the anticipatory constitutional adjudication is alien to Article 32.
There's no anticipatory over here. We're not seeking an anticipatory bail. He is in jail right now, counsel. What do we mean by anticipatory, counsel?
Uh, if some persons are not in jail before that, if we are going to get the bail,
Where is Raghav Menon right now?
Raghav Menon is detained.
So is it anticipatory? Is it not anticipatory?
Uh, in concern with Raghav Menon, it's not anticipatory, but in concern with if other people are also getting arrested,
On
before
what
getting
basis?
arrested,
On what basis is Raghav Menon arrested?
Raghav Menon was arrested as the AI tool flagged him as a potential disruptor.
So they're wonderfully correct in their proposition that the act is flawed. That's exactly what their statement is.
My lord, the detention of Raghav Menon was merely not done by the AI tool itself. AI tool just flagged him as a potential disruptor, but the act was carried on by the executive wing of the government, that is the
Counsel,
police itself.
tomorrow your AI will flag me as a potential disruptor and you will come to arrest me. And then you will say I can't come to the court under Article 32. Because only one person is arrested, not thousands. Is that what you're saying?
Or else vice versa. If one
Exactly.
person is arrested, we come to 30, another arrested will again come for 32, and the Supreme Court will keep on doing this only.
So for once and for all, we should just be looking at the validity of the act, right?
Understood, Your Lordship.
So you agree that the petition is maintainable.
Indeed not, Your Lordship. I'll substantiate it with my further submissions also.
Please do. But don't repeat the same thing that you're saying you'll substantiate later.
Indeed, Your Lordship. My second submission deals with no direct or real or proximate violation of fundamental rights. That is, Your Lordship, the core failure of this is the core failure of this petition. Absence of autonomous state action. That is, as per the memorial which we have mentioned in paragraph number 5 to paragraph number 6 in page 14, that Surakshanat does not act autonomously. It does not substitute human judgment. It does not exercise coercive power. Therefore, no fundamental right can be said to be violated by its mere existence. Also, causation, the petitioner failed to establish that how Surakshanat caused detention. Being a AI tool, just merely being an AI tool, how Surakshanat can detain someone, and how Surakshanat mandated police action, and also how the statutory discretion was overridden. Without causation, Article 32 can collapse. As it was stated in the case of State of Bihar versus Subhash Singh, it was a division bench judgment. The court held in that case that PILs based on speculative or assumed injury are not maintainable, and courts must guard against conjectural litigation. This authority is relied upon in our memorial again. In the present case, the petitioners allege Surakshanet may discriminate, might be biased, and could violate rights without any empirical proof. That is, the fear of misuse is not evidence of misuse. And moving on with why Bandhua Mukti Morcha case does not assist the petitioner relied on that case, but the facts of the case states that continuing bonded labor, there has to be a clear exploitation, and established Article 21 violations and victims incapable of approaching the courts. The actual ratio was PIL was entertained only because injury was real and ongoing. Violations were factually established. This requirement is acknowledged in our memorial and contrast with the present case. Here, no continuing violation is there, no helpless class is there, and no established pattern is there. Only one isolated incident by human officer is being contended. Thus, even Bandhua Mukti Morcha requires a factual inquiry, which is absent here. If I may move to my third submission.
I'm still unable to understand how Bandhua Mukti case facts are related to your case.
My lord, the Bandhua Mukti Morcha case was cited by the petitioner itself. The council just showed how contrast it is with the present case.
All right. So how you are making it relevant here? Are you opposing it the same?
My lord, I'm opposing the Bandhua Mukti Morcha case.
You are opposing it. And
Indeed,
you are the memorial of petitioner.
indeed, your lordship.
Okay. Okay.
My third submission deals with availability of the alternative remedies, which is abuse of Article 32. My lord, Article 32 is not meant to bypass Article 226. In PN Kumar versus Municipal Corporation of Delhi case, the division bench held that the court held where the disputed facts exist, technical inquiries are required. Article 226 is the proper forum relied upon in our memorial again. Case Rashid and Son versus Income Tax Investigation Commission. In that case, the court held that though Article 32 is a fundamental right, the court may refuse to entertain petitions where efficacious remedies exist. Again, it has also been relied upon by us.
Counsel, what is the efficacious remedy present to the petitioner over here to challenge the act?
The petitioners here could have gone for habeas. They could have enforced habeas corpus to bring
To
Raghav.
challenge the act, to challenge the validity of the act.
The petitioner's alternative remedy I'm talking about is merely about not approaching the Supreme Court through Article 32, but other remedies which they could have done.
Which is?
They could have gone through Article 226 to the High Court.
Can a High Court slash down the act? Does the High Court have that authority under 226?
My lord,
I think he was on habeas corpus. So you wanted whether you wanted to say that they could have approached for habeas corpus under 226?
Your lordship, I won't suggest the petitioners to do something.
Actually, I heard you stated this. I heard this. So that is why I just wanted to clarify.
Those are mere alternative remedies which they might use. Something which I'm not suggesting.
All right. My co-judge, had you heard?
Yes, I have. Yes.
You heard this? So I'm still unable to understand for preventive detention when police has arrested, is habeas corpus attracted? Number one. Number two, if an act is to be challenged, whether this can be done under 226. Can you answer both these questions? If an act which is passed by central government, by union, can be challenged under 226.
Counsel, you may proceed if you are unaware of this.
All right.
The council will get back to you surely for this one.
Sure.
Finally, why the petition is not maintainable against private respondents, which the council wanted to say is the petition also fails respondents 3 and 4. That is also in the case of Ajay Hasia versus Khalid Mujib, the court laid down that the financial and functional administrative control test should be there. And in Pradeep Kumar versus IICB case, the court clarified that deep and pervasive control is mandatory. And the application to our case here is that private respondents are not statutory bodies. They exercise no sovereign powers and issue no binding orders. They act only as technical vendors. If we look into the case of Z Telefilms Limited versus
Again here, I'm very much particular on Ajay Hasia's case. It is on agency and instrumentality of government. Any even private institutions, let that be any university, let that be any company, if they are working as if the government is working, they will be treated as agency and instrumentality of government and will be covered under Article 12 as state. This is what the your opponent counsel has argued. It is not only financial concern, not only that if a entity is getting financial support from government, then only that will be covered under Article 12. No.
My lord, but they don't have any binding orders.
But they are working for government. They are providing the data to government. They are providing the data to control the crime. Right? So what that government should have done, this particular agency is doing, covered under a particular act. Not beyond that. So that is a separate question. It can be challenged in court again under Article 12, maybe in 226. Right? That is a separate question. Or if you want here for us to decide, that will be a different petition. Or you want us to decide here, that is not an issue here. Whether those companies are covered under Article 12 or not. Right? So why to waste the time of court arguing on this?
Indeed, Your Lordship.
Okay.
Your Lordship, PIL, PIL is a policy opposition masquerading as constitutional litigation. If I may cite another case of Balco Employees Union versus Union of India, it was a division bench judgment where the court held that courts cannot interfere with executive policy unless it is patently arbitrary or unconstitutional. And also in the case of
Also, this policy appears to be patently arbitrary. I'm sorry to say that. It appears to be patently arbitrary right now.
my lord, but there's no concrete proof of this this tool being patently arbitrary.
You're flagging random people as potential disruptors and arresting them? Isn't that enough proof enough?
Indeed, not, my lord, as the it was the tool flagged Mr. Raghav Menon uh, on certain grounds, like he is not a random person.
Which are? And what is your basis of saying that there are certain grounds?
What is the surety that it cannot be next you?
Sorry, my lord.
What is the surety that you will not be the next one? Another Raghav.
My lord, that's what I argued before also. What might happen seems to be very speculative. What is happening, that is the main thing.
No, speculative, we could have said it if one single person would not have been arrested. If one person is arrested, now this is not speculative. We cannot wait till infinity that 10 more people must be arrested, then we will challenge this act.
Understood, Your Lordship.
Right? You can always disagree with both. These are the arguments. We are always open to listen your arguments, right?
My lord, if a private body performs a public function of a sovereign character, it exercises deep, pervasive, and effective governmental control. Or, like, the fact supporting the Union of Bharatvarsha and state of Madhya Pradesh is the national policy backing for the AI governance itself. Bharatvarsha has officially adopted the AI as a core governance tool under the act.
So Bharatvarsha is taking the data from these companies?
Sorry, Your Lordship.
Bharatvarsha is taking the data from these companies? These private companies?
Um,
Who
the
is
data
taking-
the data is being taken by Surakshanet.
Surakshanet, right? Taken by Surakshanet. And what is Surakshanet?
Surakshanet is the AI tool which is being collaborated with the government.
Collaborated, So if it is collaborated, there is no question of understanding even whether it is covered under Article 12 or not. It is definitely Article 12, state under Article 12. Right? So we cannot only blame that merely because this is private institution or private company, that is why the data is not reliable. Right? All the reasonable tests which are being given in Ajay Hasia's case are covered here. Although we haven't heard the arguments of opponent counsel only on this particular point, this was not an issue, I guess, in your proposition, right?
Indeed, Your Lordship. Your Lordship, my final submission would be depending on petition, which is premature and not right. There was no expert affidavit presented, there was no audit presented, and no technical proof was also given. The court is asked to act on what might happen and what has happened, and this was reiterated in the case of Secretary Government of India versus Alka Subhash Gadia.
Might and may already we have heard. Any other point?
My lord, on combined reading of the moot proposition, respondent's memorial, and settled constitutional jurisprudence, it might be clear that there was no fundamental right violation which is shown. And Article 32 jurisdiction is not triggered. The petition is again believed from the respondent side that it's speculative, premature, and procedurally abusive. Accordingly, we respectfully pray that this honorable court to dismiss this petition at the threshold as it's not maintainable. And if I may move on with third issue.
Yes, please.
Second issue will be dealt by my co-counsel. My third issue is related to the Digital Personal Data Protection Act 2023 and constitutional.
I always check the timer. Yes, please.
As we have paucity of time, if I may just summarize my main points. My lord, related to the DPDP, the DPDP Act is not attracted at the threshold. The DPDP Act applies only to personal data of an identifiable individual. In the present case, the state expressly used anonymized datasets before any processing. And once a data is anonymized, it ceases to be personal data. And the DPDP Act does not apply at all. Petitioner's concept of anonymized but re-identifiable data has no statutory basis under the DPDP Act, and there was no proof of re-identification, therefore there is no liability. The petitioners have produced no technical evidence, like I have previously mentioned, that there was no audit report, no expert affidavit, and no demonstration of re-identification. Courts cannot impose liability based on hypothetical or speculative misuse. The constitutional and statutory adjudication requires actual infringement but not fear of future harm. In Raghav Menon's detention, the Surakshanat did not detain or arrest anyone. The detention was carried out by human police officer under statutory discretion. The algorithm merely generated a non-binding alert. Therefore, there was no automated or data-driven deprivation of liberty. And the DPDP Act itself recognizes exemptions for public order and law enforcement. Surakshanat is a preventive policing support tool, not a coercive mechanism. Hence, even assuming personal data, statutory exemptions protect the state, and private AI entities like Neurovision and Cybermorph, they're mere private companies. They're not created by the statute, and they have no sovereign or coercive powers. They only act as technical service providers. As per settled Article 12 jurisprudence, deep and pervasive governmental control is required, which is absent here. And talking about public functions are not equal to constitutional liability. Merely assisting the state or performing a public function does not convert a private entity into the state. If entities like BCCI were held not to be state, private AI vendors cannot be either. And also, courts must not interfere with policy innovations. Surakshanet is a policy decision in the domain of internal security. Courts have repeatedly warned against paralyzing governance by interfering in policy choices without any proof of illegality.
And if court will not interfere, then what will happen? anything, everyone will do whatever they like. They will keep on arresting people. They will keep on making the government will keep on making the acts, the laws,
My
where
lord,
they will fulfill their own personal criteria of arresting someone. They'll target people.
my lord, it paralyzes the governance by interfering into policy choices.
It does not paralyze. Interference of court always keep a check on government's interest of self-interest of government.
Uh,
Government comes for 5 years. Court is always there.
although the court might have judicial review over it,
Might have, does
but
the court not have? Why did you use the word might
without
have?
Court is guardian
without
of
without
Supreme
any
Court is
proof of
guardian of Constitution. We will have to always take care of whether Indian democracy is going on in right way, whether the laws are under the constitutional purview.
indeed, Your Lordship, but bringing such cases to the court without any proof of illegality seems to be
There is
little.
there is a proof of illegality. There
It
is a proof of illegality.
it is not
One
true. It is
person
not
is
a proven fact.
arrested, my dear. One person, dear counsel, one person is arrested on the basis of data which is being given by a company and Suraksha AI, and on the basis of that, one person is arrested. Fundamental rights of one person are being violated,
It is
and
indeed,
this can happen with so many people.
my lord. My contention is that the detention has not been done by Surakshanet as it's merely a AI tool. The detention is done by human police officers.
So, what is human police officer? Is it not in a state? Under which act? Human police officer did it under which act?
Under the ordinary criminal procedure code.
Which section?
Apprehension. On the basis of apprehension, arrest can be done without having a base of an act, any criminal act. So this arrest was what? Suppose this arrest has been made, what the base a police officer would have taken has given that under this particular act, which has been challenged here today. You can always disagree. We'll give you liberty of time. You can always disagree. Enhance your arguments.
Uh, uh, my lord, if you give me a additional 1 minute,
Yes, I will. We will give you.
indeed, Your Lordship.
Counsel, do you have an argument that you want to develop? Because we're already 7 minutes over time.
Uh, Other than the question asked by ma'am, I would like to conclude my argument only by saying that issue 3 completely it fails completely because there was no personal data which has been proved and no
All right.
re-identification.
Otherwise, if you want to enhance any argument, you can always come and resubmit. All right.
Indeed, Your Lordship. There was no re-identification which has been shown, and also statutory exemptions apply. And private AI vendors are not constitutional actors as per the respondents. The issue 2 will be dealt by my speaker 2.
Council seeks permission to approach the dais.
The
Yes.
council seeks permission to approach the bench.
Guys, don't fight amongst yourselves. You're the same team. Which council
No,
want to
no.
approach?
I'm speaker number 2. He's
Yeah,
my
speaker
researcher.
number 2 has arrived. So, researcher, cool down, please. Relax.
Let her appear.
My apologies, Your Lordship. With the permission of the court, I'm counsel number 2, and I'll be appearing on behalf of the respondents, and I'll be dealing with issue number 2.
Okay.
The council seeks permission to approach with the argument.
Yes, you may.
Much obliged. Your Lordships, today I'm here before this honorable court not to deny the concerns about AI, but to constitutionally insulate that Suraksha Net by framing it as a lawful, proportionate, and a policy-driven policing aid. My lords, this AI as deployed here does not violate rights. And I will make 3 short submissions further. Firstly, the Suraksha Net does not violate Article 21 because it causes no harmful deprivation of liberty, as stated in subissue 2.1 of our memorial. Secondly, that it does not violate Article 40 because it is behavioral based and not identity based and reduces arbitrariness. Thirdly, that it does not violate Article 19 by any incidental impact, and any incidental impact is squarely covered by the by constitutionally permitted restrictions for public order. My lords, moving further, the Constitution does not prohibit the state from using personal data for legitimate governance purposes. For example, policing, surveillance, and identification have always relied on personal data. Aadhaar and CCTV systems are not something which is very alien to constitutional governance. They're already used across welfare delivery, security checkpoints, and public surveillance. My lords, as stated in point number 1 of the Moot proposition. My lords, moving further, I would like to state that their mere use does not violate fundamental rights, but their misuse does. Today, we are here before this honorable court to prove just that. In matters of public order, policing, and security, state action does not depend on individual consent. My lord, searches, surveillance, arrests, and preventive measures are carried out under legal authority and not permission. My lords, this case is about choosing between this case is not about choosing between liberty and technology. It is about whether the constitution of the state it is about whether the constitution of the state requires to govern blindly. And our respectful submission is that it does not. And I would like to substantiate further how. Suraksha Net is not a machine that governs people. It is a tool that assists human officers, police officers, to prevent harm before it occurs, subject to law, procedure, and judicial review. My lords, Article 21 has never prohibited preventive action. It has always prohibited arbitrary action. My lords, in the case of A.K. Gopalan versus State of Madras, it was held that personal liberty may be restricted through procedure established by law. Subsequently, in Maneka Gandhi versus Union of India, what happened? That this court redefined the test and held that such procedure must be fair, just, and reasonable. But it did not abolish preventive governance. My lords, the Constitution's position is clear. State may act preventively as long as it acts fairly and within the law. My lord, Suraksha Net does not create any new powers. And how? Suraksha Net does not grant any new authority to the police. Police officers already possess preventive powers under the criminal law to act when there is a reasonable apprehension of breach of peace. Indeed, Suraksha Net only helps them assess information better, so that the action is targeted rather than sweeping and being ignorant. This is important, my lords, because the system narrows discretion and it does not expand it. Moving further, my lords,
Just a minute. You and your co-counsel both rely on a statement which is not mentioned in the Moot proposition. Both of you say that there's a human intervention involved, that the Suraksha Net merely flags someone as potential disruptors. First of all, you start with the argument of Aadhaar and KYC. Aadhaar KYC doesn't flag anyone as any potential disruptor. You're basically labeling an individual or an entity that seems to be violative of Article 14. Secondly, the statements that both the councils are making over here are that there's a human intervention. What is the basis of you saying that?
Indeed, much obliged, Your Worship. So, the meaning of human intervention is that this app, the base of the argument is that we are relying on a thing that this is an app, this is a tool, which is for the help of the people. By people here, I mean the police officers, which can take help of this app for relying on data. For example, Aadhaar card information.
What is your basis of making this statement, counsel? That's my question. What's your basis?
To prevent any apprehended harm.
You're saying there's a human intervention. How are you saying this?
Human intervention as in this app is merely to assist people, and these people, and by these humans I mean police officers, and these police officers are taking the help of this app as a mere assistance tool
if the app has flagged someone as a potential disruptor, does the police official have the authority to not detain him, to disregard that?
Indeed. It totally depends on
How are you saying this? Where is this mentioned? Give me the factual position.
My lord, the point is that in our moot proposition, what is given is that this app is mainly made for social welfare, which is stated in the first few paragraphs of the moot memorial, moot proposition.
So if it is for social welfare, does it empower to arrest a person?
Exactly.
It definitely does not. That is my whole point. It will not empower. The app itself cannot come and arrest a particular person. Now,
So what is the scale of reliability? What is the scale of reliability? Where is it mentioned that human police officers will rely this much on this app?
Much better. I'd like to answer this question as the reliability. The quotient of reliability of this app is that you can access, as also mentioned in the moot proposition, that you can access data which is anonymized, but you can access CCTV footages, fingerprint, biometric data, etc., which will help to prevent any reasonably apprehended harm. And this is the quotient how the police officers can rely on this, and nothing more. Because in the facts given, I am total basic. My whole argument is totally on the facts. The only human intervention that I'm talking about is because this app cannot come and I'll tell you if the course allow, I'll give a very short example. Where let's say yesterday I had a dream that my friend killed me in my dream. So tomorrow morning I can't go to the police and ask that please arrest my friend. So this is something that this app cannot do. For this, we need the help of the police officers. So this app is a mere assistance tool, and that is where my whole argument lies.
Let's come to the fact sheet.
Indeed, Your Lordship.
Where is police official mentioned in the fact sheet? Draw my attention to
Your Lordship, it's not mentioned anywhere.
How are you saying that the police can evaluate the app and then decide whether they have to arrest or not?
Your Lordship, we have inferred the police officer thing is because the app was talking about preventive detention. The app was talking about how it is made for the welfare of the people, and from that we have inferred that somewhere or the other it is talking about the executive authorities of the state.
Aren't your arguments all inferences? There's no factual backing to that.
Your Lordship, this was the only thing that was mentioned in our moot proposition. So we thought we'll totally base it on facts, but this is what we have inferred as of now. And talking about the present facts, this is given in the moot memorial. This is all given in the moot proposition.
Yeah, proceed, Counsel.
Oh, my apologies, Your Lordship.
You may proceed with your argument.
Much obliged. Your Lordship, moving further. In the case of Kartar Singh versus State of Punjab, this court recognized that in matters of public safety, the state may be allowed operational flexibility as long as legal safeguards are respected. Suraksha Net respects this constitutional boundary. It supports human judgment and does not replaces it. My lord, every power can be misused, but constitutional law is clear that power is not struck down because it might be misused. In the conception of might be. In state of Maharashtra versus Muhammad Yaqub, the court held that the constitution challenges cannot be based on hypothetical or speculative harm. Because here there is no audit, no data, no expert report, no pattern of misuse which has been shown. And my lordship, I would like to say that fear is not evidence. Therefore, Suraksha Net does not deprive liberty either directly or unlawfully. Article 21 is not violated here. My lords, moving further. Article 14 does not require identical treatment of all persons. It requires rational treatment. In Ram Krishan Dalmia,
can you justify the arrest of Raghav only on the basis of this argument?
Leadership, you want me to give a gist about the
justification of why then Raghav Menon was arrested?
Indeed. Now, for the arrest of Raghav Menon, which is mentioned in para number 6 of the moot proposition, the arrest of Raghav Menon is based is given as a potential disruptor. Now here, the app has flagged him. I would like to state that the app has not arrested him. The app has flagged him as a potential disruptor, and in consequence of that, he has been arrested further. That is the whole point. The app cannot go and arrest someone.
So
It does
let
not
us
have
start
any
treating
authority.
arrest as next normal.
Your voice, your ladyship, your voice was not.
Let us now start treating arrest as new normal. If such policies
Indeed.
are in existence, yes.
I cannot get you clearly actually.
Ma'am is saying that let's start treating arrest as the new normal then, because that's what you're saying.
Most definitely not. That is not what we're trying to say. And what I am trying to establish by my arguments is that this app can flag people. This app can tell people that these are the following people who are the potential disruptors. And this app cannot take the sole responsibility of arresting someone and telling them that.
What is the question? How can you now answer the reliability on such?
The reliability part is, I'll also substantiate that. The reliability part is that
being flagged as a potential disruptor is also not a small thing.
Indeed. Your Lordship, the sole purpose of this app, if we go to the most proposition, I would like to take my Lordship the most proposition, where the sole mission of this app is an AI integration in public administration, policing and welfare schemes, emphasizing efficiency and predictive decision making. My Lord, the purpose, the whole, through this national AI mission of 2023, the whole purpose of this app substantiates in the first paragraph of the Moot Memorial itself, where the state of Himachal Pradesh, when they have launched SurakshaNet, which is an AI-powered predictive policing system, which brings me to the point why we have inferred the police officer conception to identify potential law and order risks using facial recognition, etc.
Counsel, so you're saying that, for example, if I'm a police official, the app has flagged someone as a potential disruptor. I have the right to audit whether I want to call him, arrest him or not, right?
Yes, you have the authority to arrest him.
Could you come to Moot Proposition Para 4? Could you please read the last second line for the court's convenience?
Indeed. Subsequently, internal reports revealed that SurakshaNet model that stands transparency used datasets sourced from foreign servers and had no mechanism for appeal and independent audit.
So the argument that you've been making for a while now, is that factually incorrect?
Your Lordship, now this statement which has been made, they don't have any concrete evidence about this statement.
They're inferring, like you're inferring, they're inferring. It's a report. It's an internal report has revealed this.
And it is a student-led report. It is a report because the students have made this report. This is not a report which is made from an intelligence system, right? This is a report solely based on by a student body, and that is why they're saying that these are mere opinions. This is not a very reliable source that even they can rely on. There is no intelligence report. With the permission of the court, I would like to proceed. Much obliged. Your Lordships, in Ramakrishnan Dalmia versus Justice Tendulkar, the court held that classification is valid if there is an intelligible differentia and there is a rational nexus between the object. The object here is crime prevention and maintenance of public order, undeniably legitimate. Your Lordship, SurakshaNet analyzes situations and not identities. Your Lordship, this system does not ask who a person is. It is asking what is happening. It does not rely on caste, religion, ideology, and social background. Your Lordship, it relies on crowd behavior, movement anomalies, and escalation patterns. And that is the difference between profiling people and analyzing risks. Your Lordship, in the state of Jammu and Kashmir versus Trilokinath Kosa, the court held that mere allegations of arbitrariness are insufficient. Here, the petitioners have produced no technical audit, no empirical data, and no expert evidence Article 14 cannot be violated on imagination and in the conception of fear. Your Lordships, moving further, in Union of India versus G. Gyanutham, the court recognized that decisions guided by objective standards are less arbitrary. Surakshan Act replaces instinct with indicators, and that strengthens equality rather than undermining it. Your Lordship, there is no hostile discrimination, no arbitrariness, and no violation of Article 14. Lordships, moving further, the Constitution itself permits reasonable restrictions in the interest of public order. In Superintendent Central Prison versus Ram Manohar Lohia, this court upheld restrictions having a proximate connection with preventing disorder. Surakshan Act operates precisely at this preventive stage itself. No restriction on speech or dissent is because Surakshan Act does not censor speech, bans protest, or penalize dissent. It is content neutral. It is ideologically blind and preventive, and it is preventive and not punitive. Your Lordships, in Kamleshwar Prasad versus State of Bihar, proportionate restrictions were upheld. In Madhu Limai versus Subdivision Magistrate, preventive measures to maintain public tranquility were upheld. Surakshan Act is less intrusive, but it merely informs the officers. Your Lordship, Surakshan Act does not place machines above the Constitution. Most importantly, it places modern tools under the constitutional control. In the absence of proven illegality, arbitrariness, or rights violation, issue 2 must be answered in favor of the respondent. And moving further, I would also like to highlight certain contentions from the memorial of the petitioners, where, my lord, across issues 2 and 3, the petitions have repeatedly relied on risk of misuse, possibility of profiling, and potential chilling effects. Risk, possibility, potential, my lord. But constitutional law does not operate on hypotheticals. They have cited the Puttaswamy judgment, the PUCL versus Union of India, Shriya Singhal case, but failed to cross the threshold requirement laid down in those very cases. And I would like to demonstrate here now how. Actual demonstrable infringement is and not academic fear. My lord, a system is not unconstitutional because it can be misused. It is unconstitutional only when misuse is shown or safeguards are absent. My lords, the petitioner's argument collapses at deprivation. The petitioners have said surveillance is equal to deprivation, prediction is equal to punishment, and algorithm is equal to arrest. And now I will tell you why this fails in law. My lord, Article 21 is triggered only when there is a deprivation of life or personal liberty, and such deprivation is only according to the procedure established by law. Here, Surakshan Act cannot arrest, cannot detain, cannot restrict movement. My lords, every coercive act, if any, and if it flows from an existing statutory police power, and not from an algorithm itself. My lords, the petitioner has heavily relied on Maneka Gandhi, but the judgment does not prohibit preventive governance, data-assisted policing, and intelligence-based monitoring. My lords, it prohibits arbitrariness. Surakshan Act narrows discretion by giving structural inputs. Therefore, no deprivation is equal to no Article 21 violation. My lords,
all right. Now. Take a break. Who will interpret whatever the data is being given by Surakshan Act? Definitely, police officers are going to interpret this. Surakshan Act is not a tool which is going to give a conclusive interpretation. It only can give a data. All right?
Indeed.
But what are the implications of giving that data?
Indeed.
What are the implications that is being given to officers?
My lord, the implications of giving this data is that now this is Surakshan Act is a private entity which is in collaboration with the government, as mentioned in the facts. Now, when Surakshan Act gives data which is indeed interpreted by the police officers and by the government. Now, let's say Surakshan Act here has identified someone as a potential disruptor or someone who has been flagged for something. Now, its direct implication is on the police and on the constitutional body how to interpret it, whether to arrest the person, whether to illegally detain that person, or any other measure is totally dependent on them, on the authorities, because this app does not have the sole authority to do anything.
So on the basis of algorithm, someone is interpreting and they are actually targeting people, and they can do it.
Indeed, I would like to say that this app is not solely made to the sole purpose of this app is not to just target people for no reason, right?
What is done by this? Why you are here then? Why this case is in this court? Only because one person was targeted.
My lord, you understand. But as per the present fact, it is not mentioned anywhere why that person has been flagged as a potential disruptor. We are here today in this capacity before this court, indeed, because yes, Raghav Menon has been detained, and our sole purpose is that talking. If we talk from the purpose of the moot proposition, it is not mentioned how, why, when. So that's why they're only arguing based on the fact. With the permission of the court, I would like to proceed further.
One more minute, because the repeated arguments are being done.
Indeed. My lord, is there a question?
No, there is no question. Counsel, just summarize within a minute. Last minute you have.
Summarize? Okay. Most definitely. Much obliged. So summarizing my whole point, my lord, I would like to state here that this case is not about whether technology is perfect. This is about whether the constitution disables the state from adapting to modern threats. Suraksha Net preserves human control, operates within the statutory powers, has no proven misuse, and advances public safety. Indeed, India has potentially flagged someone as a potential disruptor, but there is no proof of any misuse of this application itself. The petitioners asked this court to constitutionalize fear. Fear cannot be counted as evidence. The Constitution requires evidence, my lord. Accordingly, issue 2, and here we rest our case. With the permission of the court, I would like to proceed with the prayer.
You may.
Much obliged. Therefore, in the light of facts stated, issues raised, arguments advanced, and authorities cited, the counsel on behalf of the petitioners humbly pray before this honorable court that it may be pleased to adjudge and declare the following release. Dismiss the present public interest litigation as not maintainable under Article 32. Hold the deployment of AI-based Suraksha Net system that it does not violate Article 14, 19, and 21 of the Constitution. Declare that no liability arises under the DPDP Act, and respondents, being private technology entities, are not state under Article 12. Pass any other order or discretion that this honorable court may deem this fit, proper, in the interest of justice, federal integrity, and constitutional governance. And for this act of kindness, the petitioner shall, in forever duty bound, pray. Thank you.
Thank you.
My lord, before going to the rebuttal rounds, if I may answer the 2 questions asked by you.
You may.
Indeed, Your Lordship.
Just 1 minute.
Much obliged. Firstly, mere
Sir
collaboration.
rebuttal, you will be given the sir rebuttal.
All right. Okay, ma'am.
You must answer there. Follow the rules of moot.
Definitely, ma'am. I just wanted to say because you
Note it
informed
down.
me
Your
that.
time is already
All
over.
right. All right.
Avail your chance there. All right.
Much obliged, Your Lordship.
Rebuttal, please.
Yes, Your Lordship. Your Lordship, the counsel seeks permission for rebuttal. Much obliged, Your Ladyship. Lordship, the proposition tells that he was flagged by AI as potential disruptor by the algorithm.
The rebuttal means don't repeat the arguments which already you have argued. All right. If you have anything new to say, otherwise don't waste the time.
Indeed,
If any new
indeed, Your
argument,
Lordship.
yes.
Indeed, Your Lordship. There is no mention of police officer firstly, and as the opposing counsel has stated that we have to sought any other relief from other courts. Your Lordship, we are before this honorable bench under Article 32 because here the petition alleges that there is direct violations of the fundamental rights, and Article 32 itself is a fundamental right. Your Lordship, under the said case that the opposing counsel has stated, the Bandhava Mukti Morcha, Your Lordship, the PIL is maintainable even when the petitioner is not the direct victim, and provided there exists demonstrable infringement of fundamental rights, and which is clearly present in our case, Your Lordship. And moreover, Your Lordship, the court has held that in the existence of an alternative remedy, it does not bar the court to, or it does not bar Article 32 where the fundamental rights are violated. Your Lordship, one more thing that is the opposing counsel the stated or question was, how can we say that the incident is isolated to one person? Your Lordship, one constitutional violation is sufficient, Your Lordship, under Article 32 to invite the invoke Article 32. Your Lordship, I would not mention the case here as it is a rebuttal, but I would state that only one line of facts, that is, Your Lordship, one passport seizure triggered the overall constitutional overhaul, Your Lordship, and moreover, Your Lordship, the co-counsel contention was that the anonymized data cannot be re-identified. Then how did they flag Raghav Menon as a potential disruptor would be my question. And subsequently detained. Your Lordship, constitutional review does not wait for mass violations, and Your Lordship, dreams cannot be considered as facts anyway, and the petition does not challenge the policy wisdom, Your Lordship, but the constitutional validity and the right violations arising from the principle, Your Lordship. Much, that's it, would be my contention, Your Lordship. Much obliged.
Sir, rebuttal.
The council seeks permission to approach the dais. The question regarding human police officer will be dealt by me, and the second part will be dealt by my co-counsel.
Arey Baba, sir, rebuttal doesn't mean that again two counsel will come here.
Your
You're
Lordship,
given
it
1
will be
minute.
it will
Complete
be
your
done.
argument only by you or only by her.
My lord, I'll continue with it. My lord, as it was mentioned, it's not that the council is assuming any facts outside the record. The council is relying on constitutional structure and statutory presumptions. Firstly, the fact sheet states that Raghav Menon was detained. Under Indian law, which is parimetria with the laws of Bharatvarsha, detention is a coercive act, and that can be carried out only by a legally authorized state actor exercising power under a statute such as the BNSS. An algorithm by constitutional design cannot detain a person. Secondly, the fact sheet does not say that Surakshanet arrested him, nor does it say that the algorithm executed coercive power. It only says that he was flagged by the system and thereafter detained. The intervening legal act of detention must necessarily be human and statutory, even if the proposition does not spell it out. Thirdly, the courts do not presume illegality by silence, and unless the proposition expressly states that no statutory power was exercised or no authority was involved, the court must proceed on the constitutional presumption that the state power is exercised through authorized officer or and not any software. Therefore, my lord, I'm not adding any facts. I'm just applying the settled constitutional logic. Algorithms may inform, but only state authorities can detain. Even if detention is later found to be illegal, that illegality attaches to the act of the detention, not to the advisory system that flagged the risk. Much obliged, your lordships.
My lord, can I also substantiate with one last line? With your permission, please.
All right, do it.
Just one small line where I would like to defend our case. Like, SurakshaNet functions as an intelligence output, my lord. It is not a command. It is just a tip-off or CCTV alert. The alert that does not arrest a person.
If you have anything to counter what the petitioners have said, then you can do it. These all you have argued a lot. You must understand the procedure of court.
we just want to deny their contentions, and that is why I wanted to argue this. It's fine. Otherwise, we rest our case here. My apologies.
Right.
My apologies.
Court masters, with the permission of the judges, kindly conclude.
With the due permission of the honorable bench, with the completion of the oral submissions, I request both the finalist teams to kindly move to the waiting room. The teams are requested to remain in the waiting room, after which they will be taken to the validatory ceremony and the announcement of the results.